Today is Professor Pitea, and he's going to talk about European Union reception of international law. I think he will give you a slightly more accurate description of his own talk in a minute, but here he is. Okay,
thank you very much for inviting me to Professor Sanders. I'm very glad for this opportunity, and I really thank you for your kind and warm welcome these days. So the topic I will talk about how international law becomes a part of the domestic legal system is a recurrent topic for international and domestic scholarship alike. However, the points I want to make in this 30 minutes I will address you is that the traditional conceptual approach framing the discussion in terms of monism and dualism debate is to a large extent insufficient for the purpose of analyzing and explaining the complexity of today's legal reality. Okay, normally I don't need a microphone.
Yeah, can you hear in the back?
Yeah. It's quite strong.
Oh, for the purpose of the recording.
The camera will pick it up.
Okay, the camera will pick it up. Good.
This is particularly true if one takes as a point of observation or the perspective of the European Union, which is a peculiar legal system, which is placed in between national domestic and international law. So what I shall seek to demonstrate is that trying to describe the complex relationships and interactions among these three layers, national law, European law, and international law, in terms of formal relationships, of validity and supremacy, as the monist and dualist conceptual framework try to do, may prove to be in vain. This view also challenges the traditional way in which the relationship between EU law and international law is described. There are basic two narratives about this relationship. One is the most traditional and describes the European Union and European Union law as a friend of international law. Or, one could say, it is a narrative about the monist attitude of the EU legal system towards international. This narrative is based on the observation that the European Union is indeed a creature of international law. It is based on international treaties governed by international law, and it is an international organization of a peculiar, special kind, but still it belongs to the family, to the larger family of international organizations. It is peculiar because the founding treaties, which are now called the Treaty on the European Union and the Treaty on the Functioning of the European Union, have set up, to use the words of the ECJ, the European Court of Justice, a new legal order which enjoys autonomy from and supremacy over member states' legal systems. It creates, this legal system creates rights and obligations not only for and between member states, but also and predominantly for individuals placed under the jurisdiction of member states. EU law is directly applicable and may have direct effect in domestic legal systems. So there is, if one wants to use this category, a monist relationship between EU law and domestic, member states' domestic law. As an international legal subject, the EU is subject to international law, to customary international law and treaties to which it has consented, or to treaties with respect of which she has taken over responsibility from member states, since member states have transferred their competence in that particular area to the European Union. This is a different issues from that relating to the validity, the effect, and the rank of international law within the EU legal system, which is admittedly regulated by EU law itself, not by international. Positive law in founding treaties regulating this matter is very scarce. This is rather a construction made by the ICJ over time. And the friendly attitude of EU law towards international law, as it is traditionally described, is indeed the result of judicial activity of the ICJ. The starting point is the assertion in Agman, a case dating back to the 1970s, that the provision of an agreement, in that case it was an association agreement between Greece and the EC, from the coming into force thereof, form an integral part of community law. This was called, at the time it was community law, not union law, but I will refer to union law, European Union law generally. This applies to agreements concluded solely by the European Union, such it was the case in Agman, but also to mixed agreements, which are agreements to which the Union and its member states are party, together with third states. This is the case, for example, of many multilateral environmental agreements, because the European Union has shared competences with member states in the environmental field. The same idea that international law is a part of EU law applies also to customary law. This was very clearly stated by the court in the Rake case in 1998. These international laws, so introduced in the EU legal system, enjoy a superior rank vis-à-vis European Union legislation, secondary law, as we used to call it. And under certain conditions, they may be a parameter to assess validity of European Union acts, as well as the conduct of member states against their obligations under EU law. The recognition of direct effect, which is the expression which is used in EU jargon to indicate what international lawyer would rather call self-executing nature of the treaty. So direct effect is tested on the basis of a twofold test. First, the ECJ look at the international agreement as a whole to check whether it is intended to produce such effects in domestic legal systems, in the legal systems of its parties. And then, if this first question is answered for the positive, it turns to the analysis of any specific provision invoked before it to assess whether it is unconditional and precise enough to deploy concrete legal effect in domestic legal systems. The court case law regarding the Aarhus Convention gives a good example of all these dynamics. The Aarhus Convention is an international treaty concluded under the aegis of the UN Economic Commission for Europe. It promotes environmental democracy by providing individuals, environmental groups, and NGOs with accrued rights to access information, to participate in environmental decision-making, and to access justice in the environmental field. Access to information, participation in decision-making, and access to justice are the so-called three pillars of the Convention. I won't get into the details of the content of the Convention, but let me draw your attention to a provision which is contained in Article 9.3 of the Convention, which is material to the case we will examine. It provides that each party, and I quote, each party shall ensure that where they meet the criteria, if any, laid down in its national law, members of the public have access to administrative or judicial procedures to challenge acts and omissions by private persons and public authorities which contravene provision of its national law relating to the environment. This is an ambitious and weak provision at the same time. It is ambitious because it aims at changing a prevailing pattern in the law of contracting parties of the Aarhus Convention, in which standing to sue, and in particular to challenge acts of the public administrations or public authorities in environmental matters, is limited to those individuals which are directly and individually affected by a certain measure or situation. In other words, those whose right or qualified interest, depending on the national legal system, is at stake. So, the regulation of standing to sue in environmental matters is one of the major obstacles in the domestic legal system towards access to public interest litigation in environmental matters. The provision is ambitious, but is also weak because, as I said before, it does not identify precisely the subjects whose standing must be recognized at the domestic level. It says where they meet the criteria, if any, laid down in national law. So it seems to defer to national decision as to who should be recognized standing. The Aarhus Convention is now binding on 46 states of the pan-European region, so European states properly, but also Central Asian states issued from the dissolution of the Soviet Union. The US and Canada, that are members of the UNECE, did not sign or ratify the convention since they believe that their own domestic legislation already pursues and realizes the convention objective. The EU itself is also a party to the convention, alongside with all of its member states, and upon ratification it has made a declaration of competence which states that, I will briefly describe the content because it's very long, basically says regarding Article 9.3, the provision that I just read out, this provision is not covered by EU legislation, so responsibility for the performance of this obligation rests on member states, not on the European Union, until the Union will adopt implementing legislation. Such implementing legislation has never been adopted. Therefore, one can wonder whether Article 9.3 of the Aarhus Convention creates international obligations for the EU and therefore casts doubts on whether it is indeed a part of EU law, according to what I said before. The EU has competence in this field, but it has not exercised it, neither externally through the conclusion of the convention, because this is excluded by the declaration, nor internally because it has not adopted implementing legislation. The issue whether Article 9.3 is indeed a part of EU law and can be directly applicable within the EU legal system and in member states' domestic legal system has arisen in a case in which the Supreme Court of Slovakia asked the ECJ to make a preliminary ruling on whether Article 9.3 of the Convention has direct effect. The case before national courts was initiated by an environmental organization, Lesokranske Zokupenie, Z, I would call it, who wanted to challenge a decision of domestic authorities allegedly contrary to EU law, and in particular to a directive protecting habitat of endangered species, in that case the brown bear. The Advocate General, Mrs. Sharpston, in her opinion, suggested, as I said before, that Article 9.3 is not a part of EU law. So the ECJ doesn't have the competence to decide, to interpret Article 9.3 and to decide its effect in domestic legal systems of member states. The court, the ECJ, took a completely different view. It basically said that this procedural rule on access to justice, on standing to sue, was liable to be applicable to both purely domestic situations as well as to situations which are regulated by EU environmental law, as it was the case in the case from which the decision originated. And by virtue of this, the court said there is an interest of the Union for uniform interpretation and application of this provision of the Aarhus Convention. Therefore, the ECJ has the competence and the duty to interpret the provision, and this interpretation is binding on judges of all member states. The court said that Article 9.3 has no direct effect. This is not surprise, this comes with no surprise, since we have seen that it is conditional upon domestic regulation, the application of this provision. But the court also said that domestic judges have a duty and obligation under EU law, not under international law, under EU law, to interpret this provision in accordance with the purpose of the Convention to ensure wide access to justice. So this provision must be interpreted in a way that allows environmental NGOs to bring claims against, to challenge acts adopted by public authorities. So in fact, the result of this interpretation of the court is very close to direct effect, as an interpretative direct effect. This is important because...
So did the court then send the case back to the domestic
Yes,
one and essentially
exactly.
order them to
Yes,
interpret it that way?
The conclusion of the case was that the ECJ told the Supreme Court of Slovakia that they have, as a matter of EU law, to interpret their own procedural rule as far as possible in accordance with the objective of the Convention, and therefore they have, as far as possible, if this is possible, if there is no conflict between the two set of rules, allow the plaintiff to have standing to challenge the disputed measure at the domestic level.
But then the Slovakia Supreme Court actually had to do it.
Yeah. So this is important because in previous cases discussed before, some domestic courts of different European states, the domestic courts, even Supreme Courts like in Poland and Czech Republic, they took a very restrictive view over the effect of the Aarhus Convention, and in particular of Article 9.3. They basically excluded that this article could have any effect on the decision of a court, and that it just placed on the legislature an obligation to enact laws to promote the principles of the Convention.
I was curious, it sounds like they're using private international law analysis in the way that you described the case, in that, for example, you're saying that they classified the rule as procedural. In Article 9, they classified it as procedural.
It is a procedural rule.
And
I
then,
understand.
and then they said, therefore, it's applicable, and therefore, there's an interest of the EU. So it sounds very much like conflict of laws analysis, like interest analysis, and I'm wondering if the case is more about direct effect of the treaty, or whether it's really about conflict of laws.
I would say it's about the direct effect, because here there is no conflict between national laws. The thing that is, the question that is posed and the matter which is discussed by the court is not whether EU law or national law applies, or the law of one of the other, or another member state applies. The problem is to see whether the EU, which has a very broad shared competence in environmental matters, but has not, as we have seen, explicitly bound itself to Article 9.3 of the Aarhus Convention. The problem is whether the EU can decide what effect this international convention has in legal systems. And then the reason for the court to assert its jurisdiction is that, as such, this procedural matter of standing is not covered by EU law. This is undisputable. But it has a bearing on on substantive environmental law. And it has to be interpreted in a certain way to ensure effectiveness of substantive European environmental law. And I'll come to. And the interesting point is that a similar argument was made with regard to Article 50 of the TRIPS agreement, WTO TRIPS agreement, which deals with provisional measures in intellectual property litigation. So it was basically the same problem. The topic of interim protection in intellectual property litigation is not covered by EU law, but it can affect the application of substantive EU law in intellectual property rights. So this is more or less the...
Well, Professor Grossman raises the interesting question that comes up so often. What's a case decision really about? And what I ask you about is, well, at the same time, is it really an environmental law case and not an international law case? And what I cite is that in just the last 2 or 3 years, the German environmental law has been, they thought they had a pretty good, well-responsive system to object. But the European Court of Justice thought it wasn't quite so good, that they wanted more. They had set up a system that basically, you had your chance, but then and they wanted a much more open exposure. And so I wonder, is that really, is it environmental law that's driving this, or is it international?
It is actually, because the case you refer to is also a case about the Aarhus Convention.
Yeah.
It is more about the compliance by Germany with implementing EU legislation in the second pillar of the convention. Is access to justice related to participation in decision making. That was the issue in the, I think it's the Bund case, it's called. And I didn't mention that because of time.
Oh, no, I won't.
This is another, like this is more straightforward, because as to the first and second pillar, the others which encompass an access to justice aspect, the Aarhus Convention is EU law, and its implementation domestically is assisted by the procedural devices of European Union law. So in that case, what was challenged was precisely the fact that in order to be able to challenge a decision for which the The Aarhus Convention and implementing EU legislation recognize a certain class of person the right to participate in decision making. Those same person had to demonstrate that a right of their own was violated. So they could participate in the decision making, but they could not challenge the result of the decision making. And this is plainly at odds with Article 92 of the Aarhus Convention, and the European Court of Justice used consistent interpretation of European law, of implementing legislation with the international obligation to say, in the end of the day, that Germany had to change this very established traditional idea that standing to sue is linked to the infringement of the individual rights. Okay. So this is the first narrative. We see this case is an example of how EU law can be used to enhance the effectiveness of international law within domestic legal systems. But this is only half of the history. There is another half, which comes out from recent case law, and from this case law one could make the case that the EU is in reality a false friend of international law, and that the attitude of the ECJ in fact is a dualist attitude disguised in monist clothes. I will try to argue this with reference to cases which questions the three fundamental passages aspects of the relationship: validity of the international norm in the domestic, in this case European and national legal system, effect, and hierarchy. As to validity, we have a case which is called the Intertanko case. This is a case brought by an association of ship owners which challenged the validity of an EU directive on maritime pollution against international treaties such as the United Nations Convention on the Law of the Sea and the Marpol Convention on maritime pollution from ships. What do they argue? They basically argued that the system of the regime of civil liability set up by implementing legislation, by the EU directive, was stricter, was more burdensome than the system that states and the EU were obliged to adopt according to these two international treaties. So the first point I want to make on validity concerns the Marpol Convention, because the European Union is not a party to the Marpol Convention. All of its member states are, but the European Union as such is not. Advocate General Cockott, in that case, had argued that this notwithstanding, Marpol could be used as a parameter of validity for EU legislation, because in fact its regulations were incorporated in the UNCLOS, and through the UNCLOS had become EU law. That was, in brief, the argument of the Advocate General. The court disagreed and simply concluded that Marpol was not an agreement concluded by EU, so it was not valid as EU law. So this is an example of restrictive attitude towards the validity of an international agreement as European Union. The second question is about effects, direct effect. As I have said before, to check a direct effect, we have a twofold test. The first part of the test is whether the agreement as a whole is fit to directly deploy effects in domestic legal system. And it is well known that for a very long time, since a very long time, the ECJ has denied direct effect to the General Agreement Tariff and Trade before and WTO agreements more recently. To make a long story short, this finding was based on certain inherent features of those trade agreements. As flexible normative framework, where reciprocity plays a significant role, and whose system of dispute settlement allows for negotiated solution, or at least leaves to member states the freedom to choose compensation or compliance with the primary rule. So one can dispute that this is a fair reconstruction of the today's state of affairs of WTO, but I won't get into this argument. Just want to point out that in fact the idea behind denying direct effect to WTO was that direct effect would place you in a disadvantaged position vis-à-vis other trade partners. On the one hand, the executive power of the EU would be not prevented but restrained in its freedom in negotiation, trade negotiations, and on the other hand, foreign economic foreign companies could secure compliance by the EU and new member states with WTO law through domestic procedures, whereas EU companies could not do the same in other countries such as the US, where WTO has no direct effect, or Japan, and so forth and so on. More recently, in the above-mentioned Intertanko judgment, the ECJ denied direct effect to the United Nations Convention on the Law of the Sea. But this was done on the basis of a completely different argument, a completely different reason. In substance, the ECJ said UNCLOS cannot deploy direct effect in domestic legal systems because it is not aimed at recognizing rights and obligations for individuals. It deals only with interstate relationships. Well, this reasoning is very problematic, I would say. First place, it mixes up two different issues. One issue is to say or to verify whether a treaty gives individual rights and obligations in the international plane, at the international level. Another, a completely different issue, is if this agreement can be relied on by individuals at the domestic level with the objective of favoring compliance by the state with its international obligations. These are two completely different perspectives, and the court mixes them up. This doctrine, moreover, seems to marginalize direct effect, since we know that very few are the international treaties recognizing directly rights and obligations to individuals and persons other than states. One can make the argument that this theory of direct effect as a consequence of individual rights at the international level makes the statement that such agreements indeed become part of EU law as soon as they come into force on the international plane nothing more than an empty box, because the same agreements are valid, but they cannot deploy effect in national litigation and European Union litigation. The third, and probably the most interesting, issue is the issue of hierarchy, of rank. Traditionally, it is said that international obligations are placed on a higher level than secondary legislation. The issue of hierarchy between international obligations and EU law was at the heart of the Cadi case. It is a well-known case in which Mr. Cadi, who was enlisted by the Security Council Committee on Sanctions as a Al-Qaeda or Taliban associate, had his property frozen in application of an EU regulation implementing Security Council resolutions 1267/99 and 1333/2000. He challenged the regulation before the Court of First Instance and the ECJ on appeal. The Court of First Instance basically said that she had the competence to review the legality of UN Security Council resolutions against jus cogens norms, norms of international and customary law having a peremptory character. And then it says there is no jus cogens violation, but that was the line of reasoning. So basically the Court of First Instance placed itself as a judge of international law. The ECJ, in this case, again followed a completely different reasoning, and it first recalled that what was under review was not the Security Council resolution and its legality, but the EC regulation implementing it. And that, I quote, any judgment given by the community judicature deciding that a community measure intended to give effect to such a resolution is contrary to a higher rule of law in the community legal system would not entail any challenge to the primacy of that resolution in international law. So this is plainly a dualist attitude. The court says, I look at this matter as European law. I just have to say whether the regulation is in keeping, then it has, with fundamental principles, constitutional principles of the EU, which are the principles of liberty, democracy, and respect for human rights and fundamental freedoms. And the principle that all community acts must respect fundamental rights. Reasoning in that way, the court, the ECJ, left member states in a quite embarrassing situation, because the means they had chosen to implement Security Council resolutions, which was through the European Union, that was the object of a decision by governments, because this is not covered by competences of the EU. It is a matter of cooperation, not of integration. So the EC doesn't have competence. The EC is not a member of the UN, and formally is not bound by UN Security Council resolutions. But the member states are, and they had decided that it was the European Union who had the responsibility to coordinate their action, making uniform application, implementation of the Security Council decisions. So member states are left in an embarrassing situation because they cannot implement the Security Council resolution, but they still are, according to international law, under an obligation to do so. And it would be quite strange if they would implement nationally those measures when the ECJ has said that this is contrary to fundamental human rights. It is worth mentioning in this context that the European Court of Human Rights, which is not a European Union court, it is based on a different treaty and it has a different membership, but was faced with a similar situation with regard to Switzerland, which is not an EU member. And it also said in the end that some measures taken by Swiss authorities to implement Security Council resolutions relating to targeted sanctions were contrary to the European Convention of Human Rights, regardless of the fact that Switzerland was under a precise obligation deriving from UN Security Council resolutions to adopt that measures. In that way, there was no discretion. Okay? So here we are in a situation where the legality of an act is looked at from the perspective of the domestic legal system, regardless of the fact that this could cause international responsibility of a member state of the European Union or a contracting party of the European Convention of Human Rights. If one can say that the Aarhus Convention case we have discussed before may highlight the function of EU law as a door opener for international law in EU and domestic, national and domestic legal systems. These cases, and this last case in particular, highlights how the monist premises of the first narrative, because this is the point, the court says it is like, if you think about the decision about UNCLOS, it doesn't say EU law does not accept the direct effect, the self-executing nature of UNCLOS. It says it is UNCLOS that is not intended to have direct effect, to be self-executing. So it is a kind of monist attitude. But, in fact, this is used to realize a new form of dualism in which EU law acts as a gatekeeper rather than a door opener for international law within European and domestic legal systems. So my conclusion is the following. If the debate over these issues goes around the monism, dualism, opposition, it doesn't go anywhere. This is not the point. The point is a different one. We now live in a pluralistic legal order or setting. We have a number of legal systems that coexist. International law, international customary law, then we have treaty regimes, then we have international organizations, we have the EU, other agreements in other parts of the world. We have different forms of governance at the international level, which are not necessarily fit into the public international law classic models. We have transnational law, we have what is called global administrative law, and so forth and so on. So the problem, the real problem, is not what are the formal bases to regulate the relationships between these legal systems. The issue is not who is the boss, okay? The issue, I think, is how in this situation the rule of law can be promoted and protected. And I think this is what the ECJ did in the cases I discussed in the second part of my presentation. Because it is true that it prevented international law from being integrated in the domestic legal system of the EU and its member states. But what was the purpose of doing that? This is the right question. To use an expression that Professor Sellers uses, is this an instance of parochialism? I don't think so. If one looks at the cases, at the actual cases, can see that the objective of the European Court of Justice was to promote values such as human rights protection and environmental protection, which are not domestic values. Those are values that are promoted by international law at large. Therefore, what the ECJ is in fact doing is balancing material values and interests, which are all protected by international law. In the WTO case, or it balances maybe interest, but let's say in the UNCLOS case, it balances protection of private economic activities with environmental protection, and not recognizing direct effect to the UNCLOS and not recognizing validity of the MARPOL within the EU legal system is a way to avoid a challenge which would lower environmental protection. In the CAVI case, the issue is not to say that EU law is superior to international law, the fundamental constitutional principles of EU law are above international law, but it is rather to say that EU law is a way, is a tool by which values, internationally protected values as protection of human rights can be enforced. Therefore, my conclusion is that this substantive approach to inter-systemic coordination may be fuzzy for lawyers. Because for us, it is normal to assume that predictability and coherence of a norm is a value in itself. Leaving each legal system and its courts to make such a balance between competing values, instead of suggesting a coherent and stable formal relationship between legal orders, means accepting the possibility of disagreement in different legal systems. Paradoxically, I would say, this disagreement may indeed be functional to the rule of law. The whole saga relating to the targeted anti-terrorist measures imposed by the Security Council, a human rights violation finding in international law a source of legality and legitimacy, demonstrates that, at least in Europe, I would say, there will be a judge willing to hear the case and do justice to the victims of those violations. This judge will not probably be in Berlin, as Bertolt Brecht would say, and we do not know in advance whether it will be in Luxembourg, in Strasbourg, in Rome, in Karlsruhe, in Paris, or in The Hague. But the point is that we may finally find one.
Thank you very much, Professor Pitea, for those very interesting and perceptive remarks. And we have time for questions from the audience. He's left time so we can have a conversation about ideas that grow out of his remarks. And so I call on the audience for questions if they have them. Professor Gross.
So it's wonderful to have you here and to be able to learn more about the EU and the issues around how the EU functions. And I think this is unfortunately an area of law that US law schools don't get to spend much time on. So I'm especially grateful for you to be here. And so I wanted to know more about how the EU makes the decision to become a party to a treaty in the first place, and why it does so if all the member states are parties themselves. So what's the rationale behind that?
May I maybe take more than one question and then...
Whatever you feel most comfortable. But we have some time.
No, you didn't have a question. Okay, so I will answer. Okay, the way the decision is taken depends on the legal basis of, depends on the area, because the competence of the European Union to conclude international agreements may be found in two different ways. Either it is implicit, so in areas where the community has internal competences, it also has corresponding external competences. It can conclude international agreement, it can exercise its internal competence through the conclusion of international agreements. The other possibility is that there is, like for example it is the case for environmental policy, an explicit competence to conclude treaties. So these are different, and depending on the subject matter, the decision-making procedure is different. So I can't give a general decision. The essence of it is that the government decides within the council. So it is a council decision in the end that approves, this is the word used in EU law, the treaty, and after approval, as soon as the treaty enters into force at the international plane, this is effective also in EU law and domestic legal systems. As to the second part of your question, the rationale for having mixed agreements, as they are called, the agreements to which the EU and member states are parties together, is twofold. We have two kinds, basically, of mixed agreements. I would call them vertical and horizontal mixed agreements. Vertical mixed agreements are those agreements which cover areas, matters that fall within the exclusive competence of the EU and other that fall within the exclusive competence of member states. This is the case, for example, of the TRIPS agreement. Or the WTO agreements at large, because, for example, as far as commercial policy is concerned, this is an exclusive competence of the EU. The member states do not have powers as far as commercial policy is concerned between them and the third countries. This is all a competence of the European Union. So these are, I would say, vertical mixed agreements. And then you have horizontal mixed agreements, which are those who cause most problems, like the Aarhus Convention, which are treaties concluded in areas where the competence at the internal level of the European Union is shared between the Union and member states based on the principle of subsidiarity. So basically, to make it simple, I would say areas in which the Union makes laws through directives belongs to these areas of shared competence. So these are like environmental policy. These are areas where there is no need or no competence to enact uniform rules, but there is a need to have common objectives which are pursued by member states, which may be pursued by member states in different ways. So there is an obligation of result. For example, the Water Framework Directive says you have to do this, this, and that by 2015. So quality of waters and so forth and so on. But then states are free to choose how to reach this objective. Did I answer your question?
Yeah, thank you.
Was there a question in the back?
They can wait till after.
No, well, we were not in a rush to finish. If you have your question.
Okay, I was just wondering if it's customary in international law yet for two companies from various states to come to some kind of agreement before going to the ECJ. Is there some sort of like a mediation type of arbitration method for them to come to some agreement without taking the time of going to the ECJ?
The ECJ is not competent over disputes between private actors.
Okay.
It just deals with this competence to review the legality of acts of European institutions in general, and like general laws and regulations, as well as individual decisions, for example in antitrust. So there companies have an interest to challenge the decision affecting them. And then it has some other competence, but basically it settles disputes between member states, not so often, just a few cases, just a few interstate cases before the ECJ, but it has no jurisdiction to settle private law litigation. It can be involved in private law litigation because this litigation is brought before national courts or arbitral courts, arbitral panels sometimes, and this is a little bit more complicated with arbitration, but let's stick to the judicial solution. If the solution of the case involves aspects of EU law and interpretation and application of the relevant provision of EU law is not clear, domestic judges have the possibility or even the obligation, where they are last instance judges, to refer the case to the European Court of Justice. This was the case, for example, for the first case we have seen, the environmental case. It was not a private law dispute, but the mechanism is the same. So what the domestic court does is it asks a question of law to the European Court of Justice, who answers to that question. And the national judge is bound to follow the decision of the ECJ.
Thank you.
We have time for one more question, and I'm going to ask it. But we'll also, there will be an opportunity afterwards to have some further conversation with our speaker for those of you who want to.
May I say one thing?
Yes,
The
Professor Maxwell.
to honor your uncle and to let the students know here that we have actually offered European Union law, and we do on a regular basis. I think your uncle was the one who started it, and we've been doing it about every other year right now. And the students are interested, and they can raise that maybe conceivably more often, but it is a feature here already.
Yeah, it's true. We usually, we have a long tradition of offering EU law here, but actually at the moment are not offering it.
Well, we just did last term.
Yeah.
No, it's just last term. Yes, I got it.
Oh, I'm sorry.
So, yeah, so
Wow.
the world is as it ought to be. My question regards your interesting conclusion. Your conclusion, it seemed to me that what you said at the end was not so much a question of law as it was a question of justice, or rather a question of the relationship between law and justice. The hierarchy between international law and European Union law and other law seems to me, in the European tradition, to be rather clear. International law is at the top. The problem is, and the problem in the Cadi case was, that international institutions were making decisions that were unjust. So given a deep ideological commitment to the supremacy of international law on the part of Europe, faced with the fact that international institutions are generating unjust decisions, what do you do? And I think the problem is that international institutions, like any institution, lose legitimacy when they cease to be just. And so as a result, you're looking around for somewhere else to find justice. And that's what I heard you say, I think, at the end. And so the problem is, I mean, maybe the problem is one of a separation between international law and international institutions. I like the first instance court's approach better than I like the European court's approach, because the first instance court said, this is a question of international law. International institutions have departed from international law, and therefore we enforce international law. The European court said, we enforce European law over international law. I know they pretended that wasn't what they said, but that is what they said. So the European court is more incoherent, or it's causing a situation unnecessarily, because the real issue is the lack of fidelity on the part of international institutions to international law. And I think this is maybe more of a problem for Europeans than for others, because you have such a positivist conception of law that when the institutions say something, you feel, but we have to respect it. Yet I think that that's where you're going with this. And there's something dangerous, perhaps, in the European court move, which undermines international law in a way that the first instance court would not have done. I just want your reaction to that.
Yes, I agree. Thank you very much. This is no. It is true. It is true that that this is a very, very complex matter, because you have law and justice which are intertwined, and so in a way one has to take over on the other. But I would say that I think that what both the European Court of Human Rights and the ECJ were trying to do was to formally respect law by saying we are not challenging the legality of the UN Security Council resolutions with and the compatibility of that decision with the UN Charter. We don't have competence to do that. We are not an international tribunal to which states have given the task of reviewing the legality of the UN Security Council decisions. So, what we can do is to review the behavior of states before Switzerland, before the European Court of Justice, or the European Court of Human Rights, or the Council of the European Union, which adopted the regulation in the Cali case, against the body of law that we can apply, EU law and the European Convention of Human Rights. I think this is available, because if you read the judgments, especially if you read the Aldulimi judgment of the European Court of Human Rights, you can read between the lines that the court says that the real reason behind the decision is that they believe that the UN Charter prevents the Security Council to violate human rights of the individual for security reasons, that effective mechanisms have to be put in place to protect the rights of individuals under the UN Charter. This is the underlying idea, but the positivist tradition is saved by adopting a dualist perspective. So we decide from the perspective of our own legal system, or our small own legal system. But through this, we implement values which are shared by the international community at large, which are coherent with the direction international law is going since the Second World War. So I think this is the compromise to some extent.
Well, thank you very much.